Hi everyone, I'm Neil and I practice from 39 Essex Chambers and also teach at the University of Manchester. And I thought it might be quite interesting to have a look at the role of the Mental Capacity Act with regards to decision making under the Mental Health Act. Traditionally, these have been seen as two separate statutes. Section 28 of the Mental Capacity Act tries to draw a line between them, as does Dole's eligibility assessments. But as we'll see, there are a number of circumstances where within the scope of the Mental Health Act, we are having to consider, and it's important to consider, Mental Capacity Act issues. Now, this talk is in the context of a much wider debate about the extent to which these two acts ought to be fused, like has happened in Northern Ireland. That was an issue that was considered by the Wesley Review, but they decided at this stage not to propose further fusion. Now, in relation to the different areas of law with regards to mental health wards, of course, some patients on the left here are admitted voluntarily. In other words, they have capacity to make the relevant decision and they decide to be admitted and treated on a ward and are of course free to leave, subject to the Section 5 holding power being used. I've questioned here whether the same can be said of those who lack capacity to consent, and I'll be suggesting that if they lack capacity to consent to the admission and they're on the ward for more than a negligible period, then that's likely to be seen as a deprivation of liberty requiring safeguards, whether that's under the Mental Health Act or Dole's. Insofar as Dole's is concerned, we do have some people under that scheme, despite being on mental health wards, and that tends to arise in two scenarios. The first is where someone is detained for mental health purposes, but they do not object or would not object to either being on the mental health ward or to any treatment for their mental disorder. So essentially a non-objecting mental health patient could be subject to Dole's. The second scenario where someone might be under Dole's on a mental health ward, which would be more unusual, but does happen, is where the primary purpose of the hospital detention is to treat physical rather than mental ill health. And obviously the Court of Protection and Part 8 reviews under Dole's are the ways of challenging that detention. And then focusing in on the Mental Health Act, obviously here I've distinguished between unrestricted and restricted patients and the ways and means in which one can challenge detention. I want to look at the role of the Mental Capacity Act with regards to treatment decisions and tribunal issues and focus in on discharge from detention, because that's where we've had a number of issues regarding the interface between the two statutes. Now, when you look at human rights case law over the years, there's been limited success so far as judicial reviews are concerned. The courts have, by and large, consistently said that Part 4 of the Mental Health Act, the treatment powers, are compliant with the European Convention, in spite of the case of X in Finland. And so what we're seeing is what I've called here the Heineken effect, where the Mental Capacity Act is filtering through and reaching parts of the Mental Health Act that might not otherwise be touched by human rights law. So far as guardianship is concerned, of course, we can't treat someone under guardianship. Guardianship itself provides no treatment powers. And so any treatment for either mental or physical ill health will either be on the basis of the person's capacitous decision, or if they lack capacity, the Mental Capacity Act applies. Similarly, we can't deprive liberty under guardianship, principally because the burden of proof is on the patient rather than the guardian. And so again, the Mental Capacity Act and the deprivation of liberty procedures kick in there and interface with Section 7 of the Mental Health Act. The Mental Capacity Act also, as I briefly mentioned, has a role to play with regards to hospital admissions. Section 131 says explicitly, it makes explicit reference to the Mental Capacity Act, albeit in the context of 16 and 17-year-olds. And the Supreme Court decision in Re D is important here, because if a 16 or 17-year-old lacks capacity to consent to arrangements which deprive liberty, then safeguards are required. In other words, we cannot proceed informally in those circumstances on the basis of the consent of those with parental responsibility. And so that decision may lead to an increase in the use of the Mental Health Act with regards to young people who lack the capacity to consent to their care arrangements in psychiatric wards. Incapacity can also result in a deprivation of liberty. So the Am and Slam case, the South Maudsley case, is important here because Mr. Justice Charles helpfully sets out that in broad terms, there are three key things that someone needs to comprehend in order to have capacity to consent to a hospital admission. The first is that they are going into hospital for the relevant purpose, whatever that might be. The second is that they're going to be staying in hospital whilst that purpose is carried out. And thirdly, the circumstances relating to their possible confinement. In other words, all of the measures that affect their freedom of movement, the degree of observation, the locking of doors, the searching of property and belongings, etc., etc. So to have capacity to consent to hospital admission involves being able to understand, retain, use and weigh up the purpose of the admission, staying in whilst that purpose is carried out, and thirdly, the circumstances essentially relating to the acid test, as Lady Hale put it in Cheshire West. And so if someone lacks capacity in that regard, then we're likely to be looking at a deprivation which will require either the Mental Health Act or DOLS. So again, that's an example of how important capacity is with regards to hospital admission. And then thirdly, even though, of course, we can use the Mental Health Act where someone has capacity and refuses admission, capacity is not part of the detention criteria, like it is in other parts of the UK. As a matter of best practice, the Code of Practice recommends and suggests that mental capacity should be considered. For example, paragraph 1353 says a person who lacks capacity to consent to being accommodated in a hospital for care and or treatment for mental disorder and who is likely to be deprived should never be informally admitted, whether they are content to be admitted or not. And similarly, 1412 says, in considering whether it's necessary for the person to be detained under the Mental Health Act, decision makers must consider whether the person has capacity to consent to or refuse admission and treatment. This should be assessed in accordance with the Mental Capacity Act, which makes it clear that a person must be assumed to have capacity unless it's established that they do not. And so there, in relation to the issue of necessity with regards to detention, there is an express reference in the code to the consideration of the Mental Capacity Act. So again, those are just some examples of the way in which the MCA is important. Insofar as treatment for mental disorder is concerned, and part 4 of the Mental Health Act. Again, capacity is critical with regards to certain aspects of Part 4. So ECT, if someone, this would probably be a little unusual, but if someone has capacity to refuse ECT, or they've made an advanced decision to do so, or they've appointed a health and welfare LPA that has the authority to make this decision, then ECT cannot be given in the face of a refusal, unless the emergency powers of Section 62 apply. Insofar as the 3-month medication rule is concerned under Section 58, again, capacity is critical. And whilst in law, a second opinion appointed doctor could trump an advanced decision or health and welfare LPA in this respect, whether they consider it appropriate for medication to be given where there is an advanced decision or an objecting health and welfare LPA decision is obviously something they would have to consider carefully. Now, technically, the Mental Health Act, with regards to ECT and the 3-month medication rule, refers to a patient understanding the nature, purpose, and likely effects of the treatment, which is not exactly the same as the Mental Capacity Act, but the case law, in particular, I think it was the Wilkinson case, said, Lady Justice Hale at that point said that we should apply the Mental Capacity Act test to sections 58 and now section 58A. So far as CTOs are concerned and Part 4A that governs treatment on a CTO, they expressly refer to the Mental Capacity Act, so it has a clear role to play, and advanced decisions to refuse treatment, as well as best interest decisions by health and welfare LPAs have a critical role to play with regards to treatment for mental disorder. Moving then on to physical treatment, of course, whilst you're detained in hospital or whilst you're on a CTO, any treatment for physical ill health is governed not by the Mental Health Act, but by the Mental Capacity Act. And so physical treatment can only be provided on the basis of the patient's capacitous consent, or if they lack that capacity, best interests. And sometimes there are tricky Mental Health Act cases where there is perhaps some uncertainty about whether the treatment falls within the scope of the Mental Health Act or whether it's physical treatment. Also, there are cases where treatment is clearly physical in nature, but the steps required to implement a best interest decision are such as to require judicial authorization. So we have a lot of cases, for example, involving detained patients requiring cesarean sections, where they're refusing that treatment. It's physical treatment. And so the Court of Protection then has a role to play where they lack capacity to consent in terms of authorizing, in some cases, a compulsory cesarean section. What I want to focus on later are those cases where the treatment is borderline. Is it for mental disorder, to which the Mental Health Act applies, or is it for physical disorder, to which the Mental Capacity Act applies? And I want to look at JK and CC. And then fourthly, in the context of treatment, again, the Mental Capacity Act has a key role to play with regards to treatment in the community. So whenever someone is discharged from hospital detention, provided a CTO is not used, the Mental Health Act has nothing to offer in relation to treatment. There are no treatment powers under the Mental Health Act when someone is entirely discharged from hospital detention. Of course, we have Section 117 aftercare to address the relevant mental health needs, but that provides no authority to treat. That is only a joint obligation on the local authority and the CCG to offer a package of care to meet the person's aftercare needs. The actual authority to treat will either be on the basis of the patient's capacitous consent, or, if they lack capacity, best interests. Similarly, with conditional discharges, there is no authority to treat those on a conditional discharge. It's either capacitous consent or best interests under the Mental Capacity Act. So again, the MCA has a critical role to play in that regard. Moving then on to tribunals, I've just identified three particular issues here where the Mental Capacity Act has quite a lot to say. So we'll look at the case of SM and Live Well Southwest, which involved capacity in terms of a patient applying to challenge their detention in a tribunal. There's also a recent case involving capacity in the context of a tribunal where the patient was applying for it to be a public rather than a private hearing. And thirdly, of course, well, I won't cover this because it's fairly well trodden, but capacity in the context of conducting a tribunal and where incapacity is found, the tribunal appointing a legal representative on the basis of the YA case. So we'll come back to that. Capacity also has a lot to say, as I mentioned earlier, with regards to discharge. So not only in relation to treatment issues, but also more broadly in relation to care arrangements which deprive liberty. So let's have a look at some of these issues in a little bit more depth. So far as guardianship is concerned, the main case on this, which talks about the interface with the Mental Capacity Act, is the Blackburn with Darwin decision, involving a 45-year-old with epilepsy and ABI who was subject to both guardianship and doles, so both regimes together. Now, of course, acting as guardian, the local authority required him to reside at a care home where the doors were locked. He was under one-to-one supervision inside and out. Distraction techniques were used if he otherwise tried to leave. And he didn't like the care home and he wanted to live elsewhere. Now, of course, the guardian's power to require someone to reside somewhere is an exclusive power to the guardian. The tribunal cannot change the place of residence. They can only discharge the person from guardianship. The Court of Protection cannot change the place of residence if the guardianship is still in force. And so this case is important because firstly, it confirmed that we can't deprive liberty under guardianship. Secondly, it confirmed that we can use both pieces of legislation. On the facts of this case, Mr. Justice Peter Jackson decided there was no deprivation of liberty, but of course that would be different since the Cheshire West decision. And importantly, the guidance from the court was that given the exclusive nature of the guardian's power, if guardianship is not working because the person disagrees with their place of residence, we're being encouraged to ask local authorities to discharge the guardianship order to then free up the jurisdiction of the Court of Protection, who can then resolve the dispute as to residence in the context of a best interests framework. Okay, so that's quite an important decision because, again, it illustrates the role of the Court of Protection in residence decisions. But also, as I said earlier, any treatment provided can only be on the basis of capacitous consent or MCA best interests. And at the bottom there, certainly since the Cheshire West decision, I think if this happened now, we would be saying that is a deprivation of liberty under the Mental Capacity Act. So far as admission is concerned, one thing we need to be mindful of is people falling through the gap, falling between the two stools of detention safeguards. We have had a number of cases where a DOLS team has gone out to a mental health ward and concluded that the person is not eligible for DOLS. And so they fall away, that set of safeguards fall away. The Mental Health Act team come in and conclude that the person does not meet the criteria for the Mental Health Act. And so those safeguards fall away. And that leaves the individual extremely vulnerable, no doubt deprived of liberty on a mental health ward without either set of safeguards. And that's what I've described as the new Bournemouth gap. And so it's incredibly important in that situation to do our best to ensure that Article 5 safeguards are provided, which usually involves raising either a safeguarding concern or applying to the Court of Protection to sort out the sort of legislative mess and ensure that the person's rights are properly protected. Let's then move on and look in more detail about the issue of treatment for mental disorder. The JK decision is quite useful because it summarizes all of the key decisions in this area. And I'll just explain what this case was all about. It concerned a 55-year-old with autism, and he was on remand for allegedly murdering a close relative. And since he arrived at prison, he had been consistently saying that he wanted to die and that he intended to starve himself to death. He'd refused food for 23 days and then ate a limited amount for a few days because he was concerned that he might be found to lack capacity if he was in a weakened state. Now, he was transferred under Section 48 from prison to a mental health ward, a medium secure hospital. He had set up an advanced decision to refuse food and medical treatment, although that was in many respects irrelevant because fundamentally those involved in treating him were of the view that he had capacity to refuse food and medical treatment. Now, of course, the general rule in healthcare is if you've got capacity and you refuse treatment, there is nothing that can be done. Section 63 of the Mental Health Act, however, provides an exception because that does authorize treatment for mental disorder, even in those circumstances where the patient is capacitously refusing. And so the issue was whether food and medical treatment amounted to treatment for mental disorder. Was this treatment for autism? So the local health board, being a Welsh case, applied to the inherent jurisdiction to seek a declaration as to whether or not essentially this was treatment for mental or physical disorder. Did it fall inside or outside the scope of Section 63? And it was held that this required a full merits review. And the judge said that the interrelationship between the patient's mental disorder and the treatment proposed is one primarily of medical expertise rather than legal analysis. Notice, therefore, that there is a certain amount of deference given there to the view of the treating team. Now, the team's view was that this was treatment for autism. And the judge agreed that JK's refusal to eat was a manifestation of his autism. Now, she didn't rule, so it therefore fell within Section 63. She didn't go on to rule whether it should then be authorized. And in particular, there's a sort of a remaining issue about whether the purpose of force feeding was to alleviate or prevent a worsening of autism for the purposes of Section 145. Instead, what was decided was that the local health board should go and prepare a treatment plan based upon the court's clarification and to return to court if treatment was required. So that's an interesting case where there was uncertainty about whether this was treatment for mental or physical disorder. And following on from the guidance of Mr. Justice Baker in the case of an NHS trust in A from a number of years ago, he said where there is doubt whether treatment falls within Section 145 or 63, the appropriate course is for an application to be made to the court to approve the treatment. Similarly, in the case of CC, this involved a patient under Section 3 who was 34 with psychotic depression, mixed personality disorder. He was also deaf, had diabetes and end-stage renal failure. And again, the issue was whether or not this fell within the scope of the Mental Health Act. Was dialysis treatment for personality disorder? And the short answer was yes. And again, there's a certain amount of deference here to the treating team's view. And the judge said that the need for dialysis stems from CC's self-neglect. The reason his diabetes has resulted in kidney failure is to a large extent because of that self-neglect, which is a consequence of his mental disorder. It seems to me clear that the physical condition he's in, by which dialysis is critical to keep him alive, is properly described as a manifestation of his mental disorder. So these are, there are a number of these cases where the interface between the Mental Health Act and the Mental Capacity Act in the context of treatment decisions is being judicially examined on the basis of a full merits review, which is important because it can be extremely difficult for patients to challenge treatment decisions at the moment, given the thresholds of judicial review. Now, if you're familiar with the Wesley recommendations, it's interesting that there are many recommendations for changing the Mental Health Act to capacify it, if I can just describe it in that way, and try to rebalance the power between patient and clinical team in the context of treatment decisions by, for example, expanding the jurisdiction of the tribunal to consider treatment decisions. Whether, of course, those recommendations form part of any amendment act remains to be seen, and we should know more about the government's view on that when it publishes its white paper shortly. Moving then on, fourthly, to consider the role of the MCA with regards to tribunal decision-making. The case of SM and Livewell concerned a lady who was detained under Section 2. She applied to the tribunal to challenge that, but it concluded that she lacked capacity to make that application at the time, and therefore, by virtue of the tribunal rules, the tribunal lacked jurisdiction to consider the application, and her case was struck out. Now, there were a number of issues in this case. The first was whether the test for application capacity was appropriately set out in the case of BS. And what we have here is a split decision In the minority, it was held that the relevant information for deciding to apply to the tribunal was simply that you want to be free to leave. But the majority decided that the VS case was correct, and that the relevant information that someone needs to be able to understand, retain, and use and weigh up when making this decision to apply to the tribunal is firstly that you're detained, and secondly that the tribunal has the power to discharge you from detention. And the upper tribunal said that that threshold of capacity is a low one to try and ensure that patients can effectively exercise their Article 5 rights. The issue then arose, what do we do in a situation where someone applies to the tribunal but lacks capacity to do so? And there is a significant amount of guidance given in this case. The majority said that wherever possible, those involved on the ground should alert the patient and their lawyer if the patient's capacity to apply to the tribunal is in issue. If they lacked capacity at the time of applying, but have since recovered capacity, then the tribunal can invite a fresh application and proceed on that basis. And this is obviously important because incapacity goes to tribunal jurisdiction. And thirdly, otherwise, the issue is whether the patient had capacity at the time the application was made. Crucially, the tribunal said that if you are in this sort of sticky situation where an incapacitated application has been made, the way to plug the human rights gap, if I can put it that way, is to ensure that a request is made to the Secretary of State for a referral. In terms of who should do that, the upper tribunal said that hospital managers should raise this possibility with the Secretary of State if the patient themselves lacks the capacity to do so. But also anyone, in fact, anyone can request a referral from the Secretary of State, whether that's an MHA, the patient's representative, or indeed at the bottom there, even the tribunal can request that a referral is made back to them, and they can adjourn the case in order for that to happen. So a lot of guidance is given there as to how to ensure that essentially this part of the Mental Health Act is ECHR compliant, and that incapacitated patients can still effectively have their detention properly reviewed by a tribunal, and essentially overcoming the jurisdictional gap that would otherwise exist. So again, notice the role of capacity in the context of tribunal jurisdiction. The case of AR is a recent decision where a patient was restricted and wanted a public hearing. And the tribunal held that he lacked capacity to apply for a public hearing and refused his application for that hearing to be made public. On appeal, it was held that there were two errors of law in this respect. Firstly, the relevant matter was not applying for a public hearing. Instead, the matter was the patient's ability to conduct the proceedings more generally. Secondly, an error was made because even if someone lacks capacity to conduct tribunal proceedings, that does not mean that the hearing cannot be held in public. The starting point is Article 6, which confers a qualified right to a public hearing, and crucially, the best interests of the patient should be considered in deliberating whether the hearing should be made public, and in particular, the patient's wishes and feelings. So again, notice the role of the Mental Capacity Act here in determining whether a tribunal hearing should be private or public. And then a wealth of guidance was given as to how to conduct public hearings, which I won't go through, but they're set out in paragraph 20 of the judgment. The final area I want to sort of deep dive into is in relation to the role of the MCA with regards to discharging someone from detention under the Mental Health Act, and first consider the PJ case in the context of CTOs. PJ and M are two important cases from late 2018. PJ was on a CTO, resided in a care home, and there were 3 discretionary conditions to the CTO. First, to reside there and adhere to the rules. Second, to abide by the 117 aftercare plan. And thirdly, to abide by risk management plans with regards to community access. Now, the devil was in the detail of the care plan, which included a whole set of care arrangements, which were very restrictive insofar as PJ's liberty was concerned. So his whereabouts were monitored at all times within the care home. The care home had a timeout policy in place. He was escorted by staff whenever he went out, including when he went to college and met his girlfriend. Any unescorted leave had to be agreed with the RC and social supervisor. There were only 4 lots of half an hour a week, so 2 hours in total per week when he was free to go out by himself. There was an absconding protocol envisaging the use of restraint. His alcohol use was limited and he was being breathalyzed, and all of that could, well, the unescorted leave, these 2 hours a week, could be stopped if the risk factors increased. And the issue was whether or not that was lawful. Now, PJ's understanding of the CTO was that he said, and I quote, in my language, it means if you fuck up, it's goodbye everything. His understanding was that he had to listen to staff, stick to the rules. He had capacity to make decisions regarding his care plan. So obviously the MCA was not applicable here. He was happy to stay at the care home. He understood the benefits that the CTO had brought in terms of clear boundaries, but he wanted more freedom in order to see his family and his girlfriend. So can you deprive liberty on a CTO? In short, you can't. The Mental Health Act gives no such power. As Lady Hale said, the MHA does not give the RC power to impose conditions which have the concrete effect of depriving liberty. She talks about what tribunals ought to do in this situation. Then at the bottom there, she expects conscientious RCs to ensure that the conditions of a CTO do not deprive, using the acid test from Cheshire West. So what is the role of the Mental Capacity Act when it comes to CTOs? Well, as I mentioned earlier, any physical treatment for those on a CTO will be governed by the Mental Capacity Act. Either the person consents or refuses treatment if they've got capacity, or if incapacity is proven, the MCA kicks in and a best interest decision can be made. But what is the interface in the context of deprivations of liberty, given that it is unlawful to have CTO conditions that deprive? Essentially, if the circumstances are such that the CTO conditions cannot be watered down because, for example, the risks would be so high, and if the MCA is not available, then though the RC might well have to consider the use of section 17.3 leave, 17.3 being the power that the RC has to authorize others to keep the patient in custody during their period of leave. If, however, the person lacks capacity to consent to their care arrangements on discharge, then it is lawful to have CTO conditions that merely restrict liberty, that don't meet, they fall short of the Cheshire West acid test. And if they lack capacity to make decisions around their residence and care, then we can use the MCA if their care arrangements deprive them of their liberty. And that way ensure that any deprivation of liberty is properly authorized under the MCA and that the person has the necessary Article 5 safeguards, whether that's doles in a care home or the Court of Protection in any other community setting. Similarly, with regards to conditional discharges, the M case involved a 32-year-old with mild learning disability, autism, and pathological fire starting. He was restricted under 3741. There was a serious risk of fire setting and inappropriate sexual behavior. And he sought a conditional discharge on the basis that he had capacity to consent to his arrangements on discharge, and he was agreeing to those arrangements. However, the arrangements met the acid test. He would have been on discharge, subject to continuous supervision and control, and not free to leave. So a bit like PJ, the question was, is it lawful for the conditions of a conditional discharge to deprive liberty? And again, the Supreme Court said no, although this time by a majority. And the reasons Lady Hale gave were that, firstly, the Mental Health Act doesn't expressly allow for essentially community detention. Secondly, there are no coercive powers to conditional discharges. Breaching a condition is not a criminal offence, she said. It's not even an automatic ground for recall, although it may well lead to this. As I mentioned earlier, the Mental Health Act doesn't provide any treatment powers for those on a conditional discharge. Either they decide with capacity whether to have what's offered, or if they lack capacity, we use the MCA and best interests. Importantly, she also said that to allow a person to consent to their confinement on conditional discharge would be contrary to the whole scheme of the Mental Health Act, which only permits detention in a place of safety or in hospital. So generally speaking, you cannot use the Mental Health Act to authorize deprivations of liberty in the community. However, if the person lacks capacity to consent to their community deprivation, then the MCA is, of course, available and Article 5 safeguards can be secured. And that possibility was expressly left open by Lady Hale. At the bottom there, she says, whether the Court of Protection could authorize a future deprivation once the tribunal had granted a conditional discharge, and whether the tribunal can defer its decision for this purpose are not issues which it would be appropriate for this court to decide at this stage in these proceedings. So that door was left open. The government's prison and probation service have provided some fairly detailed guidance on this issue. And again, it's very similar to CTO issues. So do the conditions restrict or deprive? If they're going to deprive, we cannot lawfully, conditionally discharge. There might be the option of custodial or escorted section 17.3 leave of absence. Lady Hale didn't talk about that expressly in the M case, but the government guidance certainly offers that up as an alternative to at least enable the person to be outside of a hospital setting. But if we can water down the conditions so that they merely restrict liberty rather than deprive, then there can be a discharge from hospital detention. And of course, if the person has capacity around their care arrangements and residence, they decide. If they lack capacity, then if their care deprives liberty, we can use the MCA to ensure that that is lawful and safeguards are provided. If you're involved in restricted cases and the pursuit of conditional discharges, I would commend this decision to you, the MC decision, because it explains how to coordinate the two legal processes in terms of the Mental Health Act and conditional discharges, and the Mental Capacity Act in terms of authorising deprivations of liberty in the community. Often in these sorts of cases, there are issues not just in relation to protecting the incapacitated person from harm, which obviously is what the MCA is designed for, but also issues of public protection. And I think it's helpful to have clarity there as to when is the Mental Health Act conditions being used to protect the public, and when is the Mental Capacity Act deprivation being used to protect the person. And the case of SR and JTA sort of illustrates how broad a view Court of Protection judges might take with regards to best interest decision making, especially when there are elements of public protection involved. So by all means, have a look at that case if this is relevant. So that illustrates, there are lots of scenarios where the MCA is directly applicable to Mental Health Act decision making. And the final thing I just wanted to briefly mention is the new scheme of MCA safeguards. So the Liberty Protection Safeguards, which were introduced by the Amendment Act in 2019. The implementation has obviously been delayed because of the pandemic, but essentially next year we will have a new MCA code of practice that will cover the new scheme. There'll be new regulations, and the government is presently aiming for full implementation of the new scheme in April 2022. And I anticipate that when this scheme does come into force, we will no doubt be having more discussion of the role of the MCA in the context of Mental Health Act decision making. So I hope you found that session useful, and here are a few websites if you wish to keep up to date. Thank you very much indeed.